Welcome to the 2020 Virtual National Institute on Healthcare Fraud, sponsored by the ABA Criminal Justice Section. This session is entitled Federal and State Enforcement During COVID-19. Moderating this session is Michael Clark. Michael is of counsel at Baker, Donelson, Behrman, Caldwell, and Berkowitz PC in Washington, D.C. Michael, you may proceed with the program.
Well, thank you very much. Good morning, everybody. It's my pleasure to moderate this program. I have an outstanding panel of individuals who are going to be presenting today, and let me just kind of tell you how we're going to do this. We have a slide deck that is available, but I think we're going to probably go off script a little bit because it's always more fun than having people just read slides, to have a little bit of an interactive discussion going on, and would encourage anybody who has questions to go ahead and submit them so we can then field them live as opposed to necessarily waiting until the very end. Sometimes it's better to get that interactivity. So joining me on this program are Matthew Charette, who's a special agent in charge with the U.S. Department of Health and Human Services Office of the Inspector General. I'll tell you a little bit more about Matt in a minute. David Lazarus is an assistant U.S. attorney. He's the chief of the Asset Recovery Unit in the District of Massachusetts. Ashlee McFarlane is a partner in the Houston office of Gerger, Khalil, Hennessy, and McFarlane. And Toby Unger is the director of the Medicaid Fraud Control Unit at the Massachusetts Attorney General's office. Now, I'm going to give you a little bit more about their background. There's a lot of material that's included, and you can look at their detailed backgrounds, and I would commend you to do so. But so that we could save time, I'm first going to give you the normal governmental disclosure that is needed for the government speakers, and you understand that they are not speaking on behalf of their organizations, but rather that they are giving their personal opinions and in no way intend to bind their agencies. So let me go back and give you a little bit more about Matt Charette, who's going to be our first speaker of the morning. I've already mentioned he serves as a special agent in charge of the investigations branch at the U.S. Department of Health and Human Services, OIG. He's responsible for coordinating all national investigative activities and the direct oversight of the OIG's investigations. He began his career as a special agent in the Puerto Rico field office. As a special agent, he's conducted numerous investigations that are related to healthcare fraud and was responsible for recovering millions of dollars for taxpayers and the arrest of many providers and others. In 2008, he was promoted to the assistant special agent in charge of the Puerto Rico field office, and during that period, he supervised investigations that led to over $20 million in recoveries to healthcare programs, as well as a significant increase in criminal indictments and convictions. He was subsequently promoted to his current position in D.C. Matt obtained his bachelor's degree in criminal justice law enforcement administration from the University of New Haven, Connecticut. Moving on to David Lazarus, as I mentioned, he's an AUSA and chief of the Asset Recovery Unit at the U.S. Attorney's Office for the District of Massachusetts. He's a veteran trial attorney and a white-collar litigator with diverse criminal and civil healthcare experience. He's handled cases involving healthcare fraud, money laundering, economic crimes experience in Massachusetts and in the Middle District of Florida and New York City. Recently, he was one of the lead trial attorneys on the landmark racketeering prosecution of numerous senior executives of pharmaceutical manufacturer Freudian Therapeutics, including the board chairman and the company financial founder, John Kapoor. He's also one of the attorneys involved in the pending charitable copay case against Regeneron Pharmaceuticals. David's a graduate of Seton Hall University School of Law and Colgate University. Ashlee McFarlane is a very experienced trial attorney and a former federal prosecutor. She defends individuals and companies in grand jury and regulatory investigations, as well as criminal and civil proceedings that involve allegations of healthcare fraud, money laundering, tax fraud, and kickbacks, securities fraud, opioid diversion, FCPA violations. I got to know Ashlee when she was the assistant chief in the DOJ's criminal division fraud section, who was in Houston and led the healthcare fraud strike force overseeing complex fraud cases in Texas 2015 through 2018. In that position and as a trial attorney before, she has led and supervised dozens of investigations and prosecutions of white-collar crimes across the country that range from FCPA to False Claims Act to healthcare fraud, and tried numerous jury cases to trial. Ashlee graduated from Vanderbilt University's School of Law in 2009 Dean's List, and Spelman College with her bachelor's in 2006 Phi Beta Kappa Dean's List. Last but not least, Toby Unger graduated from Amherst College and the University of Virginia School of Law. After law school, she clerked for the Connecticut Appellate Court and then joined the law firm of Nixon Peabody. As a lawyer there, she was involved in litigating and defending white-collar government investigations. In 2003, she became an assistant attorney general and then the managing attorney in the Medicaid Fraud Control Division of the AG's office, where she prosecuted provider fraud and abuse and neglect in state and federal courts around the Commonwealth for 10 years. Then, in 2013, she joined the offices of the General Counsel for Partners Healthcare, specializing in litigation, compliance, and government investigations. She returned in 2016 to the AG's office as the chief of the Medicaid Fraud Division, where currently she leads a team of 50 lawyers and investigators in prosecuting Medicare fraud and abuse throughout the Commonwealth. So, as you can see, I have a very, very diverse and outstanding panel of experts here to present on this topic, which we think is it's kind of a fun topic in the sense that it's a bit retrospective, and hopefully at the end we can talk a little bit prospectively with the change of administration and give you some prescriptions for those of you all that defend these cases and clients that you don't want to have a chance to have up close and personal meetings with government investigators and government prosecutors on how to advise them to avoid meeting people in high government places that they probably don't want to meet in the first place. So with that, let's go ahead and move into the substantive discussions. We're going to talk as the agenda goes on about the key substantive areas of the CARES Act. I'll go ahead and cover that and lessons from the taxpayer last big funded event following the Great Recession, TARP. And I'll talk a little bit about how that gives you kind of foresight into what to expect with the CARES Act. And then we'll talk about the creation of DOJ guidances and task forces that are being used. We'll talk about the enforcement statutes that commonly come into play. We'll give you some examples of some of the current enforcement actions that have happened in the last year because of the COVID event. And then we'll finish up with state enforcement issues and that practical guidance. And so let me go ahead and move to the next slide if we could, Dr. Bronson. I'm going to go ahead and cover a little bit about the CARES Act. I've spoken about it before and written about it. These are the highlights of it, those of y'all that aren't really deep in the woods on it. It's a legislative package unlike any that I've seen in my lifetime, unlike any that I think anybody's seen in their lifetimes. So far, over $2 trillion with a T dollars are being pushed out to support the economy, and of course, a large amount of that went to the healthcare sector. $500 billion was earmarked for severely distressed economic sectors. $61 billion for the aviation sector. There are 3 separate Small Business Administration (SBA) provisions. There's what's called the EIDL, which is the Economic Injury Disaster Loan Program. Probably getting more attention is what's known as the PPP, Paycheck Protection Program, that's being administered by the SBA. And that got 350 odd billion. And then part and parcel of that is the loan forgiveness provisions within the PPP. And then not listed here, but what's called the Main Street Lending Program is also a piece of the puzzle, which was really designed for larger loans, and it's being administered through the Federal Reserve, and not all that money has been spent and funded. Next slide, if we could, please. So the key parts of the CARES Act for purposes of this discussion, there was a special investigator that was created. It's an IG, the Special Inspector General for the Pandemic Recovery, SIGPER, is I guess how you would pronounce it, that provides oversight of the relief funds. Now, when we move back to the TARP legislation, that also had a special IG that was created that provided oversight, and the reports from that agency have been pretty eye-popping about what they were able to accomplish. In Section 4018 of the CARES Act, this was created among other oversight groups. There was a Congressional Oversight Commission that was formed under Section 4020 of the CARES Act that oversees the Act's implementation through the Treasury Department and the Fed. Next slide, if we could. And then the Pandemic Accountability Committee, PRAC, oversees the use of covered funds in the coronavirus response. So what you can take from this is there's lots of eyes that have been tasked with trying to figure out what's going to be happening with the money that went out. This is a scenario where there are large strings that went out with the money. I think that the government is well aware that they don't want to do a complete pay and chase, but as you'll hear, to some extent, there has already been that phenomena, and part of what the DOJ, U.S. Department of Justice, is trying to do is to arm its staff in ways that they will hyper-focus on CARES Act investigations and prosecutions, given the enormity of the amount of money that went out, and not only the size of the money, but the number of recipients. Next slide, if we could, please. So going back to the Taxpayer Act that came out under the auspices of Congress following the Great Recession, the Taxpayer Relief Act, the Troubled Assets Program, TARP, was set up. There was that Special Inspector General for TARP that was tasked with reviewing the enforcement activities that were brought pursuant to funds that were pushed out because of the big banks and the big banks' failures and trying to keep the economic system from collapsing. But in that instance, billions went out, not trillions. The SIGTARP has made reports about what it has been able to accomplish. And bear in mind that the bank fraud statute that's out there is a 10-year statute of limitation law. And it has civil procedures as well as criminal. There's part of FIREA, the Financial Institutions Reform and Recovery Act, and that's where I cut my teeth years ago as a federal prosecutor, was overseeing savings and loan prosecutions in the Southern District of Texas, where at least every bank seemed to have failed twice or three times. That statute was amended because of the need to spend an enormous amount of time developing cases. Now, what TARP has been able to do is they've recovered over $11 billion using either the Federal Civil False Claims Act or criminal enforcement actions, sending 381 convictions and 300 people to prison. That's kind of the roadmap that's going to be followed, we would suggest to you. Next slide, please. This is just a shot of the web page that's up there. If you want to Google TARP and SIGTARP, SIGTARP, you'll find the web page that goes in granular detail about what they've done and how they've done it. Let's move on to the next slide, please. So I think at this point, I'm going to lateral it over to David Lazarus, who can tell you a little bit from the trenches about the DOJ guidance and the task forces that are up and running and new ones on the horizon for trying to investigate and prosecute these CARES Act enforcement issues. David?
Thank you, Michael. Good afternoon, everybody. Nice to be here with you today. So I think, as you can see from the slide that's on the screen, the DOJ fairly quickly, I think, identified a need that there was going to have to be coordinated enforcement activity all around the country, and they established the DOJ COVID-19 Hoarding and Price Gouging Task Force. They coordinated incoming referrals through the U.S. Attorney for the District of New Jersey, and had every one of the 92 U.S. Attorney's Office designate COVID coordinator. And it seems as though in the various offices, that was a role that was taken very seriously and was typically assigned, from what I've seen, to very serious fraud enforcers with a lot of kind of background in these areas, which I think is consistent with the theme that DOJ and the U.S. Attorney's offices plan to really take a hard look at where all this money went and is going to go. So you've got the task force that was set up with the centralized attempts to deconflict information. In addition, there was also, as Michael has said, there was the SIGPER set up, kind of like SIGTARP, and they put that in place also fairly quickly and staffed up with some very experienced senior members from U.S. attorneys' offices and around the country to try to prop that up and get it in place. I would expect, typically, like with SIGTARP, it took some time, as you'll remember, a lot of you, to get rolling between money going out, getting everything established and the groundwork for enforcement and investigation, and then finally activity and investigation and prosecution. It was similar in some ways with the BP Deepwater Horizon, which I'm sure some of you worked on or are familiar with that fund. So I think there'll be a lag between the establishment of SIGPER and the other task forces and some of the larger prosecutions. SIGPER has a somewhat limited mandate, it appears. I think that it's limited to the Federal Reserve loan programs and the Treasury loan programs, but not necessarily the SBA loan programs. And you can read their September 30th report to Congress, where they talk about what they think their jurisdiction probably is. And in that same report, they've mentioned that they've initiated, as of the end of September, 21 preliminary investigations. They referred 7 of those to other IGs, probably some to Matthew, I don't know. And also they've partnered with at least one U.S. Attorney's Office on investigations. They also noted, which I think was interesting, that they plan to continue with a very data-driven look at enforcement. And I think that that's something I'm sure Ashlee is very familiar with, and I think the fraud section really has developed those tools, as well as a lot of other offices, and so and the agencies, of course. And so they note that their plan going forward is data-driven. Their oversight includes the Main Street program, but as Michael alluded to, that has not been as widely called upon as some of the other programs. And it's possible that that's because that program doesn't have loan forgiveness on the back end. And unlike some of the SBA loans, where the financial institutions have essentially their non-recourse loans to the institutions, so their risk is none. On the Main Street program, the banks, I believe, have some amount of skin in the game in terms of making sure that those are legitimate loans and getting the monies where they should be. So those have not been as funded as some people perhaps anticipated in the beginning. But there have been a number of other task forces, as I'll talk about in a little while. The asset forfeiture community around the country has been very active in coordination with the coronavirus task force very early on, especially during the beginning of the pandemic, when there was hoarding of PPE and there was price gouging and there was a real concern about where the country as a whole was going to find enough materials for people to stay safe on the front lines. The asset forfeiture community and the task forces stepped up and very quickly began working with FEMA and other agencies to figure out new and potentially creative ways to identify stockpiles of that material and either condemn it through FEMA's process or seize it perhaps and put it into use for others. So that's more on a sort of retrospective what has happened, but there's a lot to come in the future on the asset forfeiture and on the investigation front, and I'm sure I'll touch on that more later.
David, I'd like to go ahead and pause on the slides here, and this sets up the stage, I think, very well for Matt to jump in, and he's got some materials that are not included on the slides that I'd like him to kind of cover, and then we'll come back to you and pick back up at where we left off, which would be, I think it's slide 23. So, Matt, if it's okay, go ahead and then tell us what your agency's been doing that you're comfortable talking about. I don't want anybody putting you on the spot, so please go ahead.
Thank you, Michael. Good afternoon, everybody. Pleasure to be here. I thought it might be, probably in the best interest of everybody who may not be aware of HHS-OIG, of where we came from and what we're doing, and where, we're going into this, where we started going and we're continuing to go into the COVID pandemic. Our authorities are drawn from the Inspector General's Act of 1976, which created a law enforcement arm for HHS to be solely dedicated to criminal, civil, and administrative enforcement against healthcare fraud, waste, and abuse. Within the OIG, we have separate components. We have an audit component, an evaluations component, but I'll be speaking today about my area, which is investigations. Our general workload, by the way, we're appropriated, so we work off of what our budget is required to be used for. So about 80% of that is healthcare, and as you are probably aware, Medicare and Medicaid are the biggest programs. About 20%, the other 20 are what we consider discretionary. That's our grant and contracts profile. We have HHS, or specifically National Institute of Health, is the largest grant provider in the government presently. So we do have a lot of work in that area. What many folks don't know about the investigations area is, other than the investigators we have doing this, we also have different units for more specified activities. We have a protection squad of 8 agents who are with the Secretary Azar, at any given time. We have a training unit. We have an internal affairs unit. We investigate any and all complaints against HHS employees. And we also have a digital investigations branch, which has been key through the COVID shutdowns to allow us to continue to process information. They also look at attacks against our systems, as well as assist us with processing, seizing, and evaluating digital information from our search warrants. So moving kind of into the COVID area, the challenges we had in March were, first of all, almost a complete shutdown. The level we had to first prepare for, safety for our agents in the field. And, the scramble for PPE was kind of panicked back then. That being said, of the 600 employees in OI investigations, 500 are federal law enforcement agents. What we found, our administrative folks really didn't have much of a burp as far as changing pace into full-time telework. Our agents had more of a challenge. So that's where we leaned. It was mentioned already. We leaned heavily on our data folks. We over the years we've recognized and have engaged with improving our the speed in which we get data, claims data, primarily from the Center for Medicare and Medicaid Services at CMS. It's almost immediate. We have computer specialists who process this and provide regular reports almost on a daily basis, and have learned to find red flags throughout the country. Basically, what we found is we have, in my mind, kind of like 2 buckets as far as our investigative work into COVID. We have our traditional healthcare fraudsters. And I should probably start by saying, in my experience, 99.9% of our providers are doing the right thing, but it's that small percentage that are just stealing a lot from the taxpayers. So we saw some of our old faces moving into, adjusting to the new availability of funds, particularly our labs. Prior to COVID, we had a lot of work in our genetic testing areas. We've always had traditionally durable medical equipment investigations will never go away. And then, the challenges that we had with all of the new funding was, understandably so, the government had to get this money out to those who needed it, to the providers especially, fast. And so we had gotten good about getting away from the pay and chase for the most part, but we're kind of right back into it because the importance is, the funding gets where it needs to go, and we'll find it later. So we had these traditional folks sort of just moving into this new, now COVID testing. The labs just had an easy transition into COVID testing. And then we had another group of folks with all the CARES Act funding that went out who, created companies and then applied for funding, that were not even on, the healthcare radar, prior to. So, we're watching data where instances where, an individual will open, 4 labs, all of them located within a mile of each other on the same street, start billing from one. And the first moment they have some inkling that somebody might be looking at their billing, they stop billing and then move to one of their other companies. So we're kind of tracking those as well.
Matt, could I jump in for a second? Are you seeing
Sure.
any indication of organized criminal activities coming in with different types of bad actors, rough-and mafia or things like that, or is it just kind of haphazard with no clear trends?
Well, I think it's the same trending that we have seen before. Some of the labs where we have connections from overseas. We have, the Russian mafia, East Asian, depending, down in Miami, a lot of Cuban owners, and I'm not making any kind of, determination, but that we have these connections of organized groups, not necessarily, organized groups who actually share information. They share beneficiaries. One of the issues that our digital branch works on is they dig into dark web. People they'll obtain lists of beneficiaries and share them amongst each other, and bill what they can bill and see what they can get away with. We've had just kind of spring ups. We've had issues primarily in the Midwest, Kansas, Missouri, where folks would just load up a van with counterfeit COVID tests and drive into neighborhoods and offer free testing in return for beneficiary information, which they would bill. We've had issues where a patient knowingly gives a COVID test and then gets a report from Medicare down the road that, the COVID test was run, but 85 other tests were done, and it was like a $16,000 bill as opposed to something much less for what they actually received. So that's been an issue. We rely heavily on our data analysis, and we couldn't have done any of this kind of work without a real kind of circling of the wagons with our law enforcement partners, and especially DOJ. Maine DOJ, we began regular meetings. They started in March at 3 times a week with Maine DOJ folks who were providing resources wherever we needed them. The FBI has always been a solid partner, but we also gained some new partners that we hadn't worked with in the past. SBA, OIG, with the we're finding a lot of crossover with healthcare fraud investigations, as well as the PPP loans that are going out. Everybody, the fraudsters are trying to just grab a piece of what they can while the kind of getting is good, because the importance is to get the funding out. And like I said, 95% of it is going where it should go, and it's going to treat the people, that need the services. Primarily, one of the things that we're watching and trending is there is a whole pot of money for uninsured folks. And we have I'm looking at numbers up to date, 150,000 providers nationwide have submitted claims to the uninsured portal. Basically, for anyone who does not have insurance of any kind, the government's going to pay for services that they need COVID related, whether they're infected with COVID or for COVID testing. 10 million claims have been submitted since March. Nearly 655 million has been reimbursed to these providers. And it's just the numbers are astronomical for testing services only, and 1.7 billion has been reimbursed to providers who deliver treatment services to uninsured patients. So there's a lot of money flowing, but we also know that the pandemic is a serious issue that we have to address and we have to treat. And like I said, tracking data, we have a good handle, I think, on where things are loose, but we have a lot of great partners with access to data that we don't have access to. We share that regularly. And I think that moving forward, we saw, like speaking back to DOJ, we saw a great sort of pivot with, everyone must be aware of the the strike force activities. Well, strike force sort of refocused into the COVID as well. Maine DOJ and the districts around the country are all watching and learning about the trends and the data related to the CARES Act and COVID fraud. So,
and I was going to say, I had seen before the money started flowing out, the National Whistleblower Center had written a letter to AG Barr saying we need to have a False Claims Act task force created for effectively CARES Act fraud. And, I don't want to go into the weeds too much with you, but I would assume that at some point in time, PTAM plaintiffs' counsel are going to be contacting DOJ and investigations are going to be launched to.
No, yes, that's absolutely true. Because I think related to what we're going to see a lot of related to CARES Act funding is, misuse and false statements and false claims, in the sense that, someone will purport to the government that they need the funding to continue services, pay staff, purchase PPE or whatever. But when in fact they're, buying homes and Ferraris and closing up their businesses, so that will all generally come back to, false claims type matters. We also have, folks that are selling, we've seen billing for, COVID tests that are, purchased overseas and not even FDA approved for use. We have seen some of the hoarding. I'm glad it was mentioned before. We worked with our DOJ partners. And we've also had, related to hoarding, we also worked on some cases where physicians, initially were hoarding medications for themselves and family. And it was just and it was making shortages for others in hospitals and other practitioners who needed to have access to it. So, things were, a little crazy for a while. But we are back pretty much on the ground. Our training division's also in charge of our equipment and we are fully outfitted with PPE for our folks in the field, everything from, cotton masks that all of us will wear in the office, to full out turnout gear when we have to go out into the field to do enforcement actions. And, we're doing a lot more of those, in the recent past. This last takedown that we did over the summer, was different than we'd had done before. The U.S. Attorney's offices, the districts and Maine DOJ has never been, I guess maybe us all have never really been big on, self-surrenders or summonses for criminal cases. But there was a lot of that took place just for the simple reason of safety. But those that we had to go out and get, that we did, but we did it safely and we continue to do so, not on the same pace maybe as, we have in the past. The work has changed. I think it's just evolved. The takedown that we had was the biggest numbers that we've had ever, which was kind of a surprise for us. A lot of them were cases that were worked prior to COVID. And so we feel that we're being as successful as we can under the circumstances. And, in the recent news, we're seeing that, things may be taking a dip to the worst for a little bit. And, we're ready to adjust to that as well.
Michael, can I ask a quick question?
Yeah, please do, Ashlee.
It's a little bit of a side note to something you just said, Matt, but I think a lot of us on here that defend individuals would like to know this. You mentioned the fact, given the circumstances of the pandemic, a lot of the arrests over the summer with the pandemic happened via summons or self-surrender. And I assume many of those were successful. You didn't have, folks that didn't show up. You didn't have folks that tried to run away. And you had the extra benefit of not compromising the safety of the officers having to go out and arrest people at their homes and other things. Do you think that could be a trend, given that it shows that it works, that maybe law enforcement will consider continuing to issue summons in nonviolent cases and allow individuals to surrender?
Actually, that's a good question. I think you have a good point. I think what we do in OIG, and I see that in our partners, is we continue to learn and learn from what we do and grab onto the better practices and hold on to those. I can't speak for what DOJ may choose to do. We did have a couple of cases where, When our subjects, received word that they were either received a summons or other ways that they were going to be sought after, they attempted to flee the country. We were able to grab a couple at the border. Some were, detained by other governments and sent back to us. So, but I would agree with you that it was not a high percentage of those folks that were involved in this. And, we kind of inside we joke, it seems for the last couple of years when we run these sort of takedowns in the summertime that, it just coincidentally for scheduling maybe court and grand jury or whatever, that, it always happened in June. So, we have a lot of informants who are telling us now that, well, some of your, folks that know that they're in trouble will just take the month of June off and go somewhere and not be home. So we're looking at that as well. But getting back to your point, I think with the success that we feel and the level of safety, and I think that it'll be an avenue. Generally, it's up to the investigators to determine the risks involved. But I think when they're very low, I think that's going to be an option that will be on the table more often than it has in the past, maybe.
And I can just say, I'll just jump in very briefly, Ashlee, on that. Not speaking for my office, talking just for myself in my experience. It's a case-by-case analysis also, right? So you got to listen to the agents who know the case and know the defendants and the targets and know where they're going. And there's cases where, for officer safety, you need to go in and arrest somebody. And then there's cases where that's not as significant or important to do. And so you may be right that the trend over COVID of summonses will help some people have a level of comfort, maybe even some of the agents, with the idea that you don't have to arrest everybody. But arresting is certainly something that's always, I think, going to be on the table and is going to be looked at very heavily just to make sure from our perspective that the agents are safe and the community is safe.
Yeah, and I would agree.
David, can I jump in? Are you finding that the courts are also reevaluating recommendations if, for example, they come in for a bond recommendation, that the default seems to be give them conditions of relief that don't necessarily require a jail component because of the health and safety issues? Or is that just, I guess I can only just really focus in on what you're seeing in the District of Massachusetts, but
I don't know that I would.
Go ahead. I think I may have lost you.
Yeah, my connection's a little choppy, but I think in Massachusetts, we have seen on white collar cases in particular, there's not the conditions of release are released. I think during COVID, that trend has continued and perhaps been more common on some other cases. I've noticed that we've had COVID in some of the state facilities or the local facilities where we keep people. To be fair, it's also been in the Federal Bureau of Prisons and elsewhere. But I think we've had more Zoom appearances or WebEx appearances, and I think certainly the discussion was always had about whether this is something we should be, from the government perspective, recommending conditions on. And COVID is just kind of one more factor that's in the mix there as far as safety of everybody and all the other factors that go into the mix.
Okay, terrific.
And so, David, I would just, if I could just add to that, because something occurred to me, but yeah, one of the other factors in the decision on arrest is also, the amount of money that this person, the amount of funding they may have and risk of fleeing. That's another issue. If there's a worry that sending a summons would get someone on a plane out of the country immediately, that plays into the decision process as well.
So, Matt, go ahead and probably try to wrap up if you can in maybe 5 minutes or so, if that's doable.
I think I pretty much
time as you need.
I think I pretty much covered, what I had. I know there's going to be a question time at some point, so I'm happy to cover any of that when we get there. But I think I pretty much covered what I wanted to.
Okay. Well, delightful. Thank you so much.
Thank you.
So let's go move back to the PowerPoint slides and pick back up with David Lazarus. We had a slide up about the task force creation, and if we could move up with the PowerPoint and get to that next slide, that would be great. Okay, as we wait for that, let me just throw out on this issue of conditions of release that there is a Second Circuit decision which I have tried to argue to my brethren in DOJ about the need not to arrest everybody, that deals with what we call perp walks. The awful situation where the agents take the man or woman out of the office in handcuffs, and the TV crews are there to film the whole thing. And there is a case that says essentially that it might be actionable, depending upon the motivation, if there's not a legitimate public policy need to do that. And back in the day when I was handling as a federal prosecutor, I was the chief of the criminal division in Houston. The default really wasn't to have onerous conditions of release. So I think it's good that we are now back in the scenario where the courts and the DOJ and the agencies are reevaluating: is there really a need, or can this be handled through summons enforcement otherwise? Dr. Bronson, could we get the slide deck up? Or
Michael, we see the slide. Do you not see the slides?
no, I don't see them up. So can you see the slides, Ashlee?
Yes.
I can see the slides.
Okay.
Ashlee, can you hear me?
David, the important thing is that you can handle the slides, and I'll figure out why I'm not seeing them. So
okay.
Yeah.
Ashlee, can you give me a thumbs up if you can hear me? Sorry. Or Matt, somebody.
Yes,
okay, all right. Thanks, everybody.
Yeah, I can.
Gotta love technology. It's only been 7 months of the pandemic.
Well, I appreciate it, David. So if you don't mind picking up and running through, I guess it's probably the next 6 or 7 slides, and then we'll turn it over to you and Ashlee to kind of talk about the next 7 or 8 after that.
Sure. So the DOJ put out guidance very early on about these task forces. You can find them on the web. They may be in the program materials, but essentially they say we're going to set up task forces and people need to work together and deconflict. It became an all hands on deck effort, I would say. You can go on to the next slide, please. As COVID progressed, more and more cases were spread throughout the offices, which was, I think, part of the plan and the design to tap into whatever resources were necessary. You can go on to the next slide, please. So the agencies have been very active, in addition to HHS OIG, as you would expect, the Fed OIG, Treasury OIG, SBA has been very active, the FBI, and as I'll talk about in a few minutes, the Secret Service as well. U.S. attorneys' offices, many of them entered into formal MOUs with SIGPER. There's a link for my U.S. attorney, Andrew Lelling's announcement in the materials, but there's very similar across offices throughout the country. And essentially, it streamlined the process of sharing communication and referrals so that SIGPER had a very easy way to share information about what they were seeing and vice versa. And it's all part of this common idea of let's take the skills that we have. Money has to go out the door. We have to do something about this pandemic. But again, since it's going to, by necessity, be pay and chase, let's try to be as proactive and responsive as we can be. And the toolboxes, I think, have continued to expand over time. Now, with us being in November, you can see, and I'll talk about in a few minutes, some specific examples. I think just yesterday, the fraud section, along with the Eastern District of Texas, together took down a case. They charged, I believe it was 7 people for a $16 million COVID-related fraud scheme, and they executed something like 45 seizure warrants as well. So those are the kinds of cases that I would expect you're going to continue to see as a result of these task forces. If we go to the next slide, please.
I think that was the Southern District.
Oh, I apologize. I'm way up here in Massachusetts, so it's a big state to me. And so here's just a screenshot of the the guidance or the memo that Andy Lelling put out. If we could go to the next slide, please. And here's an example of, if you look, it's April 24th, 2020, very early on, a complaint that was filed on a hoarding price gouging case. Back then, early on, there were also a few civil injunctions that were filed using 18 USC 1345, the fraud injunction statute. Those were primarily aimed at website spoofs, and there were a few large companies who manufacture legitimately PPE, and there were some bad actors who took the skills that they had learned from the dark web over the last 10 years and set up some lookalike websites and schemed to take a lot of money from people. And so in the beginning, DOJ and the U.S. Attorney's offices moved to get injunctions to shut down those websites, to try to locate the monies that the victims had paid through those sites. And as the pandemic progressed, the hosting companies, as well as the large corporations who were the victims of the spoofs, also became more sophisticated or more aware, I guess I should say. They've always been sophisticated in shutting down those kinds of situations themselves fairly quickly. And they worked with a lot of the federal investigative agencies very nicely with real excellent, quick cooperation early on in the pandemic. I think I would be remiss if I didn't say that in addition to these task forces, you still have all of the traditional enforcement that's been going on. And so it's business as usual in the U.S. Attorney's offices. Again, the agents, as Matt said, they had to sort of pivot a little and get used to how they were going to work in the new COVID type world, but they're back. Knock and talks are happening. Subpoenas are going out. Grand jury in some jurisdictions is happening again, and with live witnesses being brought in for testimony. There's a lot of sworn statements and proffers happening. And so the traditional kind of enforcement tools are also out there in addition to the task forces. And so I think there's a hard look going on and will continue at telemedicine, lab testing, DME, fraud. It's a little off this exact topic, but just this week, I'm sure many of you saw HHS-OIG put out a special fraud bulletin talking about speaker programs, and they recommended that in light of the demonstration during the pandemic that speaker programs maybe aren't necessary, they recommended, and I'm wildly paraphrasing, you should go read it yourselves, but they recommended that those not be a tool that pharmaceutical companies use going further. And so I think the task forces are out there and they're very important, but the office is also, it's a space everybody wants to be in. All the U.S. attorneys' offices want to be finding this money and helping the public in this way. And I think there's a lot of overlap with the traditional white-collar work everywhere. And I would imagine that even with the new administration, that everybody is going to want to be in the business of finding misdirected or stolen fraud proceeds. And that right now you're seeing a lot of SBA loans going out and companies or individuals pretending they had a company and buying a Maserati or a Ferrari. I think as time goes on, the more sophisticated cases will start to develop. I think you'll have much more use of CIDs, and I would imagine that the whistleblowers bar will come out and that there will be significant QTAM activity. It just takes time, as everybody knows, and I would think that the obvious, sort of more obvious in your face kind of fraud is being smacked down, so to speak, right now. And then the more sophisticated fraudsters, the organized fraudsters, they're going to be subject to scrutiny for a long time going forward.
And David, CID is an acronym for Civil Investigative Demand. Would you kind of just, for those that aren't familiar with that, just kind of explain how CIDs work? Please? Sure.
So I think I've been in the government so long, I'm used to all of the acronyms. So thanks, Michael. So CID is essentially so in our office, the Civil Division's ACE unit, the Affirmative Civil Enforcement Unit, can send out a civil investigative demand for documents and testimony in connection with the False Claims Act investigation, basically. And so it's often when a key TAM comes in, although there's no requirement that it be from a key TAM, but when a key TAM comes in, that CIDs will get sent out to companies or to individuals, similar to grand jury subpoenas and with enforcement provisions for the government as well. Our office in Boston has historically worked very closely between the civil and the criminal division. We have robust healthcare investigators on the civil side and the criminal side. And so often CIDs are used because they're not protected by grand jury secrecy. We also have HIPAA subpoenas, as we call them, that we can use through another provision of the law, which we can issue in healthcare fraud investigations, and are also not protected by 6E, the grand jury rule, which would prohibit otherwise us from sharing our criminal investigations documents or information with our civil investigations. So to streamline our investigations, we have historically used a lot of the more civil tools. But so I think my point on the CIDs is that I think that in time, companies should expect to see more demands from the government looking for information as more sophisticated, as reports come in of more sophisticated fraud that may have been taking place.
Excellent. Thank you. I think we can move into the next slide, which I believe are some of the potentially applicable criminal statutes. And perhaps, David, you and Ashlee can jointly kind of walk through some of these. I think there may be actually, I can't remember if there's one or two slides that go through all the statutes, but you know, there's been a study that's been done, actually more than one study that's been done about the numbers of federal criminal laws that are available to charge, and some of them are more exotic that have seen recent use, like the Travel Act got some notoriety with some prosecutions around the country in ways that weren't anticipated. You know, one thing about the Travel Act that stood out to me, for example, is that it doesn't necessarily have the same protection available to the defense that the anti-kickback statute has with its statutory exceptions and its safe harbors. So why don't you guys run through some of these statutes that are potentially applicable, and I'd love to hear other voices. Thank you.
Sure, Michael. I think one thing you'll notice about these is that, like you said, they're not more of the exotic. They're the normal tools that you see in white collar and healthcare fraud investigations. And oftentimes what's being charged in the COVID fraud cases is wire fraud. You can do a wire fraud conspiracy and some substantive counts. It makes it very easy, a very easy indictment. And as David said, they're focusing, a lot of the prosecutions right now are sort of the low-hanging fruit prosecutions, the folks that are, you know, if it's the PPP loans that they're asserting that they have companies that don't exist or employees that don't exist, and going out and buying Maseratis and Porsches and all of that. And a lot of that, you don't need a travel act to indict that. And, you know, I think David talked about it a little bit earlier. The way that they're finding these cases is very akin to the way the healthcare fraud unit is set up. It's data analytics. They are receiving the data from the largest banks across the country. They're looking for a certain amount. They're looking for certain indicators, whether it's the amount of money that was received or where the money went after they received it, and being very proactive, as I'm sure David will tell you, on these cases, and not really waiting for something to fall in their lap. But they're, you know, I had one AUSA, and I won't mention which district, tell me that it's like fish in a barrel right now. There's so many targets available for prosecutors and for law enforcement all over the country in this area. And so you'll see oftentimes the same statutes, the false statements, the wire fraud, the mail fraud, the conspiracy, that you'll see in other traditional healthcare fraud cases and other white collar fraud cases as well.
And so along those lines, as Ashlee just mentioned, the financial institutions are helping contribute information. FinCEN, which is the Financial Crimes Enforcement Network, has been very busy and proactive. They've issued at least 3 guidances to to all financial institutions and to their law enforcement partners. At a conference in late September, the director of FinCEN, Kenneth Blanco, talked about almost $325 million in COVID-related recoveries so far. And I thought it was very interesting that SARS, suspicious activity reports that financial institutions have to file to report activity that looks odd to them. So, for example, a brand new account opening up and then receiving $1 million SBA paycheck protection loan, all the money going out and then it shutting down the next day. Just hypothetically, that's something the banks are getting good at noticing, and they should file a suspicious activity report, which is then reviewed by law enforcement agencies, U.S. attorneys' offices, DOJ analysts. And so between February 1 and September 12th, according to FinCEN, there were over 91,000 SARs that were filed around the country referencing COVID-19 or the stimulus program. And so this goes back to the theme of there's a lot out there. The obvious ones are sort of probably floating to the top through database searches of those SARs, but it's going to take a lot of time for people to sift through those SARs and find the more nuanced fraud schemes and the sophisticated fraud schemes that are out there. But as Ashlee said, people are paying attention, the banks are watching, and so the information is out there.
And
I know that the SBA has put word out that essentially they're putting a threshold of $2 million just to make it workable. But the question I guess I have with the SARs, suspicious activities reports, is whether the banks and the savings institutions are just reporting everything to reflexively report, and so that way they can be criticized, or if the trend is that these are actual legitimate reports. I mean, in the old days, that became a problem with the savings institutions, is they knew they wouldn't get criticism if they reported everything. And so I just wonder, David, out loud, if that's a phenomenon, if there's any quality control being done in that regard.
So I think to the credit of the financial institutions and also the public-private partnerships that I know we have in Boston, but also we had in Middle Florida, and I'm sure exist all over, the financial institutions and their money launder, their AML groups and others have worked, I think, very hard to not just file those sort of to protect themselves for CYA. I think FinCEN has been working hard to put out very clear guidance on what is and is not reportable, and how to report things is also, I think, become more sophisticated in terms of, what buzzwords to use, what language to use, but also because of the relationships that now exist and have, existed for some time, I think that the agencies also get, heads up from some of these financial institutions when a particularly serious or egregious or ripe SAR is filed. The Secret Service, for example, has been very, very active. And you can Google this and see this. They've been very active in identifying misdirected SBA funds or allegedly misdirected SBA funds and going out and seizing those for forfeiture. And so there's a North Carolina press release you can Google where the Secret Service, they said, went out and found some SBA fraud proceeds, and other agencies too. It's not just Secret Service, have sort of good contacts in place to find out what the good SARs are. And then there's lots of other, and by good, I mean actionable criminal conduct that somebody should take a hard look at. And there are other SARs that obviously have that conduct, but that are going to take time.
Okay. So we have a whole panoply of federal statutes that can be used. Obviously, bank fraud is a very powerful one, given the high sentencing guidelines, availability, the long statute of limitations, and then, as Ashlee mentioned, wire fraud, mail fraud, or old workhorses in the government. Conspiracy is another. And forfeiture, I think, obviously is going to play a big piece here. Is that right, David?
Yeah, so I think since it's sort of gone to pay and chase, you could probably call it pay, chase, and seize. Forfeiture is going to be very involved, and that is all part of the same theme of early proactive involvement by the government. Nobody wants to be caught sort of sitting around now and in a few years say, I wish we had seized that money before it went overseas, which is something we're seeing a lot of, or before it went from bank account to bank account and was drained. And so forfeiture has been working very closely, as I said, with the other groups within U.S. attorneys' offices and on their own to identify money, to go seize it. Of course, there's also our traditional forfeiture tools. We can trace money. So even if it does go other places, we're very good at now tracing funds and finding property involved in money laundering. And we have other powerful tools like the relation back doctrine. So if somebody buys something with fraud proceeds now, the law gives the government essentially place in line at the time that the proceeds were used to buy that property. So later, when we find it and discover that somebody bought a mansion with it or bought an office building, we're going to be able to enforce our rights, or at least look to enforce our rights then. So forfeiture is going to be a significant part of, I think, this whole narrative for a long time. And I would imagine that the criminal cases that will continue to come out of the 92 U.S. attorneys' offices, and I think it's 92, and DOJ will include forfeiture in significant ways.
Okay. Should we move to the next slide?
Sure. I would want to say one thing. It's amazing to me, and that this. I think for years to come, it will be debated about whether this had to be pay and chase, because it reminds me of the problems that we've had for a long time with the Medicare system. And I know, Matt, you're very familiar with that. The fact that you have the funds are needed immediately, and you figure out whether someone whether they were warranted for legitimate services or not later. But it seems like we should have figured out a way to really put more safeguards in place when giving out this kind of government money in the first place. So I think that may be something that will be debated for years to come.
There's a report that was included in the materials that is not part of the PowerPoint slide deck that I would commend the audience to take a look at. It's generated by Arnold and Porter, and they have been keeping a tally of all the COVID prosecutions, and so you have the most current version of that, along with a web page that you can go to and kind of follow what's been going on in this regard. But we've pulled down some examples in the next slides that come from a report from the Congressional Research Services called COVID-19 DOJ Enforcement Against Scams, that goes through, the cases as of July 20th of 2020 when this report to Congress was made. It's an outstanding report, which is also included in the materials. And again, to kind of look at what's going on across the government enforcement on the federal side, it's a great discussion. All the CRS reports are very well done. This in particular is one of several that CRS has put together for Congress. Others are also included about what the SEC is doing and what other agencies that are part of the enforcement web are doing. And again, I would commend those to you. But Ashlee, why don't you pick up and run through, you and David, some of these examples that you think are more potentially interesting to the audience about the enforcement activities and the low-hanging fruit that's been caught.
Sure. And I think really the way that this progresses shows the progression of enforcement efforts. At the very beginning of the pandemic, you have a focus on price gouging and fraudulent websites trying to sell PPE. And you'll see that in this first slide and maybe the next slide as well. You've got folks who are setting up, fraudulent charity scams, ways to get donations to help medical providers or other people who are suffering from the pandemic. And you've got the PPE with either they're not providing what they say, or they're not up to quality, or they're just sending empty boxes. And that evolved over time to more of, if you go to the next slide, and let's go to, is this the malware 15? One more slide. But I think, yes, right here. And we get to enforcement activity focusing on these websites and malware. Again, this was already happening. You had hackers putting up websites to try to attract people to click in order to install malware on your computer, on your phones, in order to get your personal information. They just pivoted to make it related to COVID-19 information. And in this particular case, it was focusing on Johns Hopkins University's tracker, COVID-19 tracker. And so it was sort of a website that was not the legitimate website, that if you clicked on it or if you downloaded an email attachment related to it, that they would install this malware on your computer. And, I think as of April, it was found to be there were about 51,000 virus related domains, and 99% of them, were suspicious or fraudulent related activity. And that was back in April. So very early on, almost 10% of any COVID related domains were looking to be suspicious activity. David, you want to pick up the next slide? Is he on?
Yes, I'm here. Sorry,
okay.
I had to find the mute button. So just another example of thieves using stolen PII. They'd use them in the tax context. I think there was a lot of stolen identity refund fraud that had been perfected over the last very long time, which is another kind of pay and chase. The IRS has to issue these refunds. And so there's a lot of PII floating around on the dark web from massive data breaches. There have been a lot of recent malware attacks you can read about in the news. And so all of that information, as Ashlee said, that's out there has been used and is being used for unemployment fraud and for all other types of bad acts right now. Rhode Island, in late October, arrested 4 people and seized more than $1.2 million in another COVID-related fraud scheme involving a number of different criminalities. I think that's another common theme that I think both Ashlee and Matt have touched on, which is, it's not as much necessarily just that people are stepping up and applying for one SBA loan. It's, they're applying for either multiple loans or they're applying for multiple SBA loans. And they're also, establishing, a fake lab so they can bill for services they haven't rendered, and they can take the money and run to open a new lab when somebody starts looking at them. So I think it's going to be a lot of these kind of cases using a lot of the statutes that we saw a few minutes ago to try to get at the heart of this conduct. That Virginia civil forfeiture case that was referenced a few slides back, it was a pretty basic scam involving PEPE being offered at inflated prices. Then they set up a mechanism essentially to take orders and collect money, but they never shipped anything. And so the FBI and the U.S. Attorney's Office fairly quickly got involved and seized, I think it was about $540,000 that are part of that case. And in their press release, interestingly, they also thank the COVID task force, which again comes back to this common theme.
And I think we can go on to the next slide. So this again is focusing on the PPP loans, which we've talked a lot about, in the false loan applications, whereby they are certifying that they have businesses they don't have, employees they don't have, using the funds for payroll or rent or other legitimate expenses, and then instead of doing that, buying Ferraris and the like. So those are the cases that we're seeing right now all across the country. And as David said, there was just one filed yesterday in Texas, actually a couple states, but there were 80 different loans that were involved in that case. So far, I believe over 70 defendants have been indicted related to PPP loans, and certainly over 250 million related to PPP in particular. We've talked about the fact that they're using data analytics to find these cases and are focusing on the most blatant instances right now. As an example of the volume of this, last year, 2019, the SBA, the Small Business Administration, received about 800 or less than 800 calls of potential fraudulent loans. This year, so far, it's been over 40,000 just related to COVID. So from 800 to 40,000 complaints to the SBA gives you a little bit of a sense and context of how much is really out there. We've only been in this for 7 or 8 months. I would say related to the PPP loans, there's about on average 10 or so individuals indicted a month. And the statute of limitations is nowhere near running. So this could be going on for years and years to come.
Yeah, and a 10-year statute of limitations, as I wanted to just urge again, is important because bank fraud has a long statute of limitations. And so I would suspect that is going to be in the pipeline for a long time to come. And then on the False Claims Act front, certifications are being made about eligibility and use of the funds by borrowers. And that's obviously a basis for trying to piggyback those false certifications into actionable false claims. And so I think that, there is obviously a way that plaintiffs can come forward and file key TAMs. The question is going to be how big are the loans and how big are the statutory damages.
That's right. And I do think on the more nuanced cases on these certifications that there could be some real legitimate defenses. I think very early on, it was unclear exactly what these certifications meant and some of the language in the certifications and what was necessary, how much funds were necessary in order to keep your business going. There were representations made by lenders and others to borrowers that may not have actually been accurate. And there were a lot of sort of changes in those regulations very early on. So I think it's likely the government won't get to those kinds of cases on the criminal side because there's so many of the other blatant cases. But I do think there could be there are certainly some defenses in the more nuanced cases.
I think we are now at the point, last but not least, Toby's last name fell in the alphabet at the back, but the state has been quite actively involved and continues to be involved in working on this same problem that is definitely affecting the state budgets. And I'd love to hear you kind of tell us what's going on from your experience in Massachusetts, if you don't mind, Toby, and pick it up from here.
Sure, thanks. Well, I'm sure no one's going to be surprised, but the reality is, we're just a microcosm of what you guys are seeing federally, and that, especially during the first few months of the pandemic, and even I would argue until today. We're still the stuff that's falling in our lap as far as COVID enforcement issues. It's all the low hanging fruit, just like you said. So, we, on this slide, I'm talking about some of the just really obvious stuff that has been coming our way, in the last few months. And it's things like, when Massachusetts, went into sort of lockdown back March, April, May, obviously we had some non-emergent, non-COVID related, physical services continue to be billed when that was, illegal to be doing that, like physical therapy or even sort of non-emergency dentistry, right? And so again, that stuff showed up people were aware of it, but mostly it was the data analytics. So again, sort of a microcosm. The state seems to be a microcosm of the national government there. So data analytics, low hanging fruit, like really basic, obvious crime, none of the nuanced stuff. The other things we saw was abuse of the telehealth waivers. So Massachusetts, essentially said you can do almost anything and everything by telehealth and sort of on an emergency basis back in March and April. Again, I am sure in the future there is going to be a lot of complex and nuanced fraud with respect to telehealth, but the sort of things that we heard about and have been hearing about in the last 6 months are the obvious stuff, like a doctor who literally just left voicemail messages for every single one of his or her patients, checking in, and then build the highest evaluation and management code possible across the board. So again, sort of that that showed up in the data as a huge red flag early on, and was referred to us by a variety of different agencies who were watching that data. So again, really sort of obvious stuff is what we're seeing and what we're dealing with. And I am sure that the more complex fraud is yet to come, but it has not been referred to us in these, the last 6 months, 8 months, etc. So the other thing is, again, that you guys have talked about this also. I mean, same thing. Fraudulent PPE, issues, faulty COVID tests, COVID protections, and hand sanitizer, even that, is it's being sold. It doesn't at all comply. Again, not nuanced. Like we have a case that was just announced out of Massachusetts today, I believe, either today or yesterday, but it involved a company that sold hand sanitizer to the MBTA, our subway system, and I don't think it had any alcohol in it. So I mean, it wasn't an effective hand sanitizer. So again, the basic stuff, not on the margins. This is sort of the blatant fraud that we're seeing still at this point. People have talked about the same thing. Using telemarketers, going out there and just calling Medicaid and Medicare beneficiaries and saying, COVID-related themes, we can get you even a lanyard or all sorts of kinds of medications and tests for COVID, and we can get that to you for free if you'll just give us your Medicaid and or Medicare numbers over the phone. A lot of people did that. That PHI is then sold to telehealth companies, rent-a-doc companies and or sort of DME companies that fraudulently bill based on the stolen PHI. So we're seeing all the same things, I guess, on the state side, and it's still the most blatant. It's the most blatant and obvious crimes, COVID-related crimes that we're seeing at this point, and I do believe there will be a lot more complex fraud in the future, but we haven't seen it. We haven't seen it yet.
Do you have in Massachusetts a analog to the False Claims Act, a mini False Claims Act under Massachusetts law, Toby?
We do.
Okay.
And so, we can jump to that. I was going to talk about the state COVID immunity laws.
Okay.
So, because I think there's interplay there, which I think is going to be an interesting situation. So, let me see it. Courtney, if you could move forward, I guess, skip the next slide. We can come back to that. Here we go. Okay. So, about 31 states have passed, either by legislation or executive order, essentially a state immunity law to provide protection, primarily for healthcare workers and healthcare facilities who are acting in good faith during the COVID state of emergency. I took a quick look, and I believe 31 states passed COVID immunity laws. All of them are still in effect because the emergency is still ongoing. And so the interesting piece here, I think there's a number of interesting pieces here, is all but, New York includes protection against both civil and criminal liability. While the vast majority of everybody else, the other 30 states involved, either explicitly or implicitly sort of focus on protection with respect to civil liability and primarily negligence, with sort of exceptions and limitations, hitting, gross negligence or wanton and reckless behavior or sort of intentional behavior. But Massachusetts is the only state that explicitly carves out from the state immunity statute our state False Claims Act, as well as sort of consumer protection actions brought by the government and discrimination actions. But so that False Claims Act piece is interesting, I think, because I'm not sure how that's going to play out. I think there obviously there's an argument that False Claims Act liability would fall above negligence, right? At least reckless disregard, at least in our state, and so therefore would be exempted from these immunity laws. But again, other than Massachusetts, I don't think that's dealt with explicitly in any of the other state immunity laws. So I think that's going to be an interesting there's going to be litigation, obviously, as soon as the state of emergency is over. The other interesting dichotomy here in these state COVID immunity laws is that about half of them are focused solely on providing immunity to healthcare providers and healthcare facilities, and the other half are actually provide this sort of at least tort immunity to bars, healthcare providers and healthcare facilities, but also state agencies and sort of all businesses, including sort of bars and restaurants and gyms, etc. So again, about half of the 31 are focused solely on healthcare providers and facilities, while the other half are significantly broader. So I do think, again, they're all still in effect. So once the state of emergency is over, I think there's going to be a lot of litigation trying to understand exactly the scope of those immunity laws.
Yeah, I can understand the Good Samaritan law aspect of for healthcare providers that are having to deal with a virus that there was really no known regimen to treat with initially. But I guess from a standpoint of immunizing others that are doing services like bars and restaurants, I guess that's more of an employment law focus. But it's interesting to hear this. This is as you say, it's going to be very interesting to see how it plays out across the country. These state immunity laws and how far it's actually going to protect some of these actions.
Well, I'm guessing obviously that the broader immunity statutes, right, we're based on trying to convince the local businesses, right, to continue to operate during the pandemic, right?
Makes sense.
Yeah. So they're more economic versus healthcare oriented.
So are you experiencing qui tam relators counsel knocking on the doors? Not again, I don't want to get into the weeds too deeply, but I would assume with the state COVID immunity law that may make it a scenario that could effectively eliminate a lot of False Claims Act that are specific to Massachusetts law being broad.
Well, we specifically exempted the False Claims Act in our state immunity law.
That's
so.
That's what I thought.
Yeah, but again, that there you do not have that explicit exemption, I believe, in any of the other state immunity laws. So, and so the answer is just recently. I mean, we have traditionally received at least 3 to 5 sort of qui tam filings a week. They definitely slowed down for the first, 6 months of this pandemic, but recently that has picked up again to sort of the same at the same rate. And it's just recently that we're starting to see COVID-related qui tams being filed, at least in Massachusetts. And the focus does seem to be the labs. I think that's going to be the next after the low-hanging fruit. I think people are going to be looking pretty closely at labs and how they handle testing.
Well, thank you. Anything else that you want to add before we start opening it up to questions and hearing from the audience?
No, I mean, we've done in Massachusetts, we've done a lot of work with respect to COVID in the nursing homes. But I do believe there's going to be another session on that in another hour or so here. So I won't get into that in detail. But we devoted a lot of our time and attention in the first 3-4 months of the pandemic to what was going on in the nursing homes and whether there was fraud there or sort of egregious conduct by management on with respect to basic COVID protections, and determining whether that was, that constituted abuse or mistreatment or neglect. So that was, again, as a state Mafuku, we have to devote a lot of our resources and attention to that for the first, I would say, half so far of this pandemic.
Okay. Well, I do recall a lot of activity up in Massachusetts in the nursing homes, New York State as well. A lot of reports out of Washington State, and it is quite troubling to see our most vulnerable, the elderly, that it becomes an incredibly infectious disease when it gets into those settings with people that have immune systems that aren't really working particularly well when they're in close quarters. So with that, I thank the panel. You've been outstanding, and the practical guidance slides are up. And just generically, in any dealings with the government as defense counsel, be straightforward and honest from the get-go. It always works better if you can tell them, your position and why. Those in industry, there are some really nuanced issues that have happened, particularly with the PPP loan program and the shifting guidance from the SBA. And there's still time to rectify situations where there may be some gray areas, and getting counsel advice we think is incredibly important. But getting a handle about the applicable rules and regulations for loans is not something that is necessarily that easy. And again, I think that's reason to seek out knowledgeable counsel. And I don't know if we have any more slides, Dr. Brown. My favorite expression in the criminal parlance is the old homily, pigs get fat, but hogs get slaughtered. A lot of fraud activities is simply a follow the money exercise, and the more money that's taken in, the higher the likelihood of becoming a target, not only for criminal investigation, but for key TAM relators. And so there's a lot of information that is being digested here, and let's go ahead and open it up. We're now ready to begin taking questions from our live audience, and all attendees can submit questions through the chat feature of the webinar interface. And we'll wait to see if there are any questions, but if none are forthcoming, what I would like to do in the last couple of minutes, we've got roughly 5 or so left, is to circle back with each of the panelists and just kind of pose a question to you. What do you expect to change with the new administration coming in, other than, of course, U.S. attorneys and their staffs will be shaken up, obviously, with the change in regimes. But, as agencies, if this is going to create a new direction, and what are the coming attractions that are anticipated here on the horizon? And then finally, to the extent you're comfortable talking about the kinds of the data analytics that are being performed, I think it might be very informative for the attendees to hear a little bit about how the government has moved into data analytics and how data analytics are helping fraud investigations and developing skills. And it's a more intelligent way of doing some targeting, that coupled with key TAM relators that are insiders coming in and saying, I know fraud and here's what happened. So I don't see any questions. Don't be shy in the audience. This is your chance to throw out a question or two if you'd like. But as we wait, let me do this. Let me start with you, Matt. What do you anticipate in the next year or so that's going to be any different than what we've seen in the past several months in the COVID-related fraud investigations? I know that your agency always puts out wonderful reports about what it plans to be doing, where it sees vulnerabilities in the Medicare program, what steps could be taken, and so on. But do you see any major shifts that are likely to happen?
Thanks. I think everybody here, and I can't speak for our front office and, the acting IG, obviously. But I think we're still kind of wait and see. The benefit that we have, in a sense, is because of our independence, although the Inspector General does report to the Secretary, our work is not necessarily directed by the Secretary. It's completely independent. But I can say that one of the changes that we had to be versed in with the last administration changeover was that Obamacare could not be referred to as Obamacare any further. It was ACA. Moving on. So I think there might be focuses. Certainly we do listen to Congress and to, and issues. We do have projects ongoing now in the nursing home arena, which, as you mentioned, is a particularly, an environment for particularly vulnerable, folks. We will continue and probably enhance our data analysis. We haven't stepped away from the opioid, work, but we're at the point now, and we have tools in place where we can connect claims of someone passing away in a hospital due to opioid overdose, and then track back to who is it that was prescribing those. So we have a whole pocket of work there. But as far as what we're looking for, I think we will always continue on. There's always sometimes changes in priorities. Like we were huge on opioids. We're still there, but it's not being advertised clearly as much as it was, and I think everyone understands the seriousness of COVID. So I think we're mostly wait and see, but we always hustle while we wait. So we're kind of see how it goes.
So we have a question, and it's a good question. I open it up to everybody. Are grand juries meeting in your respective jurisdictions? If not, when do you anticipate grand juries will resume? I recall reading some months back that the Southern District of New York reportedly was even thinking about convening grand juries using Zoom or similar technologies, which to me seemed like a really out there type of a proposal. But grand juries have to meet, and I know that in Southern District of Texas that grand juries are meeting, and I'm assuming that David and others that you're seeing grand jury activities starting anew. Is that right?
So yes, so our grand jury is open, and our grand juries are open, I should say. And we have a high volume of cases that go through there. We always do. We're what the department calls an extra large district, so we have a lot of volume. A number of other jurisdictions do have in-person grand jury hearings, proceedings happening. I think with what appears to be this unfortunate resurgence of the virus, there have also been some jurisdictions that are closing their grand juries, at least temporarily, to try to get this under control. But the push, grand jury has to continue, and the courts have recognized that, and they've been trying to open them when they can.
Well, I tell you what, I hate to do this, but we just are at the point now where we have to sign off and let the audience take a break, and then we'll come on into the next excellent session, that is fraud and abuse in nursing homes, that starts in roughly 16 minutes. So on behalf of the panelists here, and thank you for your excellent work, on behalf of the ABA, Gabe Imperato, who chairs the National Healthcare Fraud Institute and the Planning Committee, and the ABA Criminal Justice Section, I hope you've enjoyed it. I'm Michael Clark, and thanking you all for joining us and paying rapt attention. As I said, please join us for our next session, Fraud and Abuse in Nursing Homes. And during the break, we encourage you to browse the virtual lobby for any open network sessions. Thank you.